And we are live. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near, give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. With me on the panel this morning are Justice Mary Sullivan and Justice Shin. We have one case on for hearing this morning, rescheduled from its originally scheduled date of December 10th. That case is case number 2020 P33, the Commonwealth versus DENITA D. GOFORTH. You may begin.
Thank you. May it please the court, Jessica Kenny on behalf of the Commonwealth. As you're aware, this was an argument that was heard in the Brockton District Court, and in a margin notation by the motion judge, it was denied. The motion was allowed, simply citing to Commonwealth versus Pena, finding that there was no nexus to the place to be searched. The interesting thing about Pena is that when you look at the history of cases that have come almost immediately after Pena, there are cases beginning the very next year that start distinguishing other fact patterns from Pena, all the way up until what I learned recently, this past September of 2020, after both my sister and I had submitted our briefs, that this court issued a decision in Andre Fields, again, distinguishing Pena and giving quite a history of how these cases can be differently applied and how the facts can change this. So this is not Pena. This case is not Pena because Pena was won by. And even since Pena, we know that there can still just be one controlled buy with other evidence, and it can establish a sufficient nexus. But this case is three buys. It's three controlled purchases. And in them, on at least each occasion, there is an indication that the target at the time, the individual who is known as Wiggy by the CI, and a car registered to him and operated by him, is at the target address before and or after the buys. I
want to drill down into that a little bit because you may not have noticed that, but I have happened to author the majority opinion for the appeals court in Pena before the SJC took further appellate review and expressed a different view than I had. So I'm familiar with both Pena and its progeny. But my recollection of the facts in this case is that while there were multiple buys, there was only one in which there was surveillance seeing the defendant leave the house, get into the car, and then a short time later appear at the meet location to complete the buy. There was no surveillance that directly observed him going back to the apartment, although the car was observed back there approximately an hour later. But for our purposes, in establishing a nexus, I suppose, it's the departure from a known location to go directly to a sale that offers the strongest suggestion that the residence is used as the stash location. But still, we only have one buy in this case where that occurred.
That's correct, and that's the strongest. You're talking about the second buy, where police now they had an address because after the first buy, they followed him back to 10 Abbott, and so for the second buy, they're ready for that. They go to 10 Abbott, they watch an individual matching the description of our target, come out of the house, get into a car. Again, we're talking about a car that's registered to him, and then that's also the case that within an hour the car is back. Now, of course, it's not direct surveillance, but we're dealing here in probable cause, not in perfect surveillance, not in absolute certainty.
I understand that, but you've only got the one buy where you have all of that. And on all of the other occasions, we have no idea where he was immediately prior to the sale.
Well, that's correct. The first buy, we have no idea where he was immediately prior to the sale. But the third buy, we know based on independent surveillance that was done at 8 o'clock that morning that now the second car that the target was using is parked out in front of that house. And that's that Camry with the Pennsylvania license plate that again is seen not only on independent surveillance being parked at the house, but independent surveillance. They see
there's no information in the affidavit about times on that day, right? So they see the Camry in the driveway I think it was 8 in the morning, right?
Correct.
And then the third buy occurs and we don't have any information about when it occurred. So
Correct.
We don't know if he left the house and went to the buy.
Correct. Again, it's not perfect, but we know that at 8 o'clock in the morning, which again is important because I think that shows that this is the house that the target has control over and that he's residing in as his primary residence.
I don't know.
Well,
I don't know how it shows that, but before we even get to that assertion, where was the car immediately prior to the sale?
Again, we don't know exactly immediately, but what this case
Where did the car go? Let's assume for a moment that Wiggy left the house at 10 Abbott and used the car to travel to the meet and complete the sale. Where did he go in between? Do we know?
We don't, but what this case has that a lot of the other cases don't, like Calgon and like the case that was just decided, Fields, is the time it takes from when the order is placed and the buy is arranged until when he shows up. And in this instance, it's 10 minutes. The first buy is also 10 minutes.
But we have no idea where he was in when that 10 minutes started to run. You're asserting and asking us to assume that he was at 10 Abbott, but there is absolutely nothing in the affidavit to establish that as a probability.
We know that the car that he drove to the buy later was at 10 Abbott at 8 o'clock in the morning.
Correct.
And then that it was at the buy within 10 minutes of the drugs being ordered.
Right. But I mean, it's, I guess I don't need to say it, but I will. Cars have a tendency to be mobile. And the car could have gone to many places between 8 in the morning and 10 minutes before the call, right?
Except that at the second buy, we know that it goes directly from the home to the buy. So
on one occasion,
right?
But, just as in Pina.
I have a separate question about the affidavit. Notably omitted from the affidavit is the affidavit says that the red Mercedes is registered to Wiggy, but it doesn't say where. Was the motion judge permitted to infer from that very significant omission that the car was not registered at 10 Abbott?
I quite frankly, I'm not sure about the answer to that question. I mean, was the motion judge permitted to say, well, you know, they may have failed in their burden on probable cause by so important an omission? I don't think that in and of itself can fail in probable cause, because again, what we have here is, you know, obviously a drug delivery service, especially where he's utilizing multiple cars. So he utilizes 2 different cars to sell the drugs, and there's a third car at the residence also registered to his name. That's the BMW.
Well, what is the proof that that's his residence? There was no overnight surveillance. There's unlike Escalera, there's no interview with the landlord. Is there anything to show that it's his residence?
So it doesn't have to be his residence. It just has to be a residence that he has access to. But
understood.
So there is independent surveillance, again, that sees his multiple cars registered to him, parked out there. I think anytime they drove by and did surveillance, at least one of his cars is observed there.
So you would agree that there's no evidence in this record that that's his residence?
Well, I slightly disagree. So again, remember the defendant actually was referenced by the CI, and although not implicated in the controlled buy, she was certainly someone that the investigators were looking into. And there is direct evidence that this is her residence, because there are police records and there's a board of probation record that tied this address to her, and this is her husband. And we know this is her husband.
No, it's her husband, because there's no marriage certificate.
No, that's correct. But she told police previously during a previous encounter about about Wiggy or Mr. Wigfall.
8 years earlier, if I recall correctly.
Right. Why no marriage certificate if you've got $360 a year gets you an ancestry account? You know, I appreciate in previous times that might have been a difficult get, but you know, a kind of quasi hearsay report of marriage.
I mean, again, I think her statement to police in that context, there would be no reason for her, you know, 8 years prior to this drug investigation, for her to misrepresent their relationship. And it was consistent with the information that the CI had provided them. And again, it shows him being at the house. And so it's probable cause. We're not dealing in, there's no other possibility. There's plenty of cases where, there's even evidence that a target has access or lives in a different address. But the point is, every time
having access is a different proposition from making the relationship of the individual to the target location such that it's reasonable to infer a likelihood that that they are using that location to store an inventory of illicit contraband that they're going to be selling.
Correct.
And,
but there's
and if
no
he is
other
a
address.
visitor, it's different. That is a different question if he has access as a visitor than if he has access as a resident. You're suggesting that her statement to police, characterizing him as her husband in 2011, is adequate to support a conclusion that he's living there because he's still her husband in whatever the year this was, 2018, 2019. But sadly, relationships found her in shorter periods of time.
Well, except that he is seen there by the police multiple times.
Yes.
So I mean, either they're still married and that's his home because it's reasonable to infer that husbands and wives live together in single family homes, or he literally has the best relationship ever with his ex, and he still can come and go from her house as he pleases before and after drug deals.
Oh, you lived a sheltered life. I mean, the cases that we see have all kinds of complicated arrangements.
Again, it's
including
reasonable.
those that are marked by the circumstances that gave rise to the police encounter in 2011.
It's certainly reasonable, though, that he has at least access to the house, if not that he's living there. He's parking 3 cars that he's using, 2 of them that are registered to him there.
Isn't it reasonable to infer that the 2 cars would be registered to his address, and that if, in fact, it was registered to 10 Abbott, that it would be in the affidavit, going back to Judge Sullivan's question? We're talking about 2 registrations.
Right, and I disagree because, again, what we know about this narcotics scheme is that he's utilizing different cars. And again, the Commonwealth's argument would be that he's packaging and bringing the proceeds back and making the deals, and the cell phone that he's using is at the house. And then he's rotating these different cars, again, potentially to avoid detection by the police. And if he registers those cars to the house, well, then it's now tied the place where he's selling and packaging the drugs to the place, that he's delivering them with. So it's not fatal. And there's obviously plenty of cases that talk about, defendant or targets using these sort of shell cars and shell phones. And
that's a great explanation if only it had been in the affidavit. If the officer had said in my area of expertise, people use multiple cars. They don't register them to their home. But I return to my concern that a savvy motion judge could look at this and say, if they're not willing to tell me where this car was registered, why should I be issuing a warrant?
And I think that that's fair, that if it's, anything lacking from the warrant, obviously you can't say that it benefits the Commonwealth. I mean, the detectives are I don't think that it was intentionally omitted. I don't know. Again, I don't know the answer. Obviously, whether it was just inadvertently admitted or if it was admitted, not.
We're not here to assign blame. All we're here to do is assess the adequacy of the showing against the Commonwealth's burden. And look, I understand that these cases fall across a spectrum with all kinds of different indicia, but in order to establish that he was a resident there, they could have shown that in a variety of different ways. Other than the suggestion that an 8-year-old comment in response to a domestic violence disturbance, I don't think it said violence, but a domestic disturbance.
Family disturbance.
Yeah, so. Okay. Well, okay. A description of him as her husband at that time and the frequent observation of the car at the location, there's very, very little to suggest that he was in fact living there as a proposition of fact.
Respectfully, again, I disagree. I think that every time they did surveillance, he or his cars are seen there, even though it's not perfect. It's not directly before the buy and directly after the buy. He's going to.
He uses the cars from time to time. We don't know that.
But he's seen going into the house, and he's seen coming from the house.
On occasions, yes, but that's different from status as a resident as compared to being a visitor.
Well, again, even if he's, the argument is that he's keeping his drugs there. And so the fact that he's seen coming and going into the car before and after the buys is important. And you do. to get to Justice Sullivan's question, just very briefly, I'm running out of time. I recognize that the officer didn't explain this drug distribution scheme and the use of, cars that are registered to different addresses. But at this point in the case law, I think there are some liberties certainly that the magistrate can take, and certain things, and the case law certainly supports this idea. And we can say that the magistrate can understand at this point the general practices of a drug distribution ring. The point I would leave you with is, PINA is one buy, and we have one, what I would suggest, perfect buy. That's the second buy. And the others, while they might not be perfect, they might not be textbook, at that point, they're gravy. They're in addition to what the perfect buy establishes in the middle. And so there's a little bit at the beginning and a little bit at the end, and there is certainly room for inferences to be drawn, but that doesn't need to be perfect because it's already more than what we had in PINA. And again, we have this very, very quick turnaround. Every time they call, it's 10, 15, 20 minutes before the drugs are delivered. Every time, no questions asked.
Thank you. Okay. For the defendant.
Thank you very much. Thank you very much, Your Honor. Just picking up on what my sister said, yes, inferences can be drawn, but inferences are not a substitute for facts. Inferences are drawn from facts, and inferences must be reasonable. And in this case, they, I think that they're asking the motion judge to draw inferences in the absence of fact. Going back to Judge Sullivan's question, yes, I do believe that a savvy motion judge who is not presented with information that details a registered address for vehicles, which surely would have been available to the police, could draw the reasonable inference that the reason the information is not provided is because it does not favor the investigation, and it's because those vehicles are not registered to 10 Abbott Place. That information was certainly available to them, and it draws, it sort of.
Well, let's say that's true, but he doesn't have to live there for there to be probable cause to search the location, right?
No, he doesn't.
It's Clagon says quite clearly after Escalera, whether the suspect owns the premises, lives there, or merely conducts business there, the question is whether evidence is likely to be found there. So let's assume that the cars are registered elsewhere. Is that fatal? Why isn't there enough?
It's not fatal, but it isn't enough because there isn't any additional information to lead to the conclusion that drugs will be found at the premises. I know, Your Honor, during the suppression hearing, one of the first questions that the motion judge asked the Commonwealth on page 7 of the transcript was, is there any information in the search warrant that there are actually drugs at 10 Abbott Place? Essentially, the judge is saying, what have you got for me? And the Commonwealth's answer was, no, Your Honor. The Commonwealth then went on to try to argue that there are inferences that can be drawn from these various drug transactions. But in the cases we see where there's no direct information from a confidential informant, typically that the informant has previously purchased drugs from the target of the search warrant, and there's no claim that the CI bought drugs from Wiggy prior to this. What we have is—
Wait a minute. The affidavit, though, says that they were tipped off by the CI that Wiggy and a, quote, black female with a medium build, approximately 5'3", with blonde hair, were dealing to, and that he knew this from firsthand information.
Not firsthand information, Your Honor. I must disagree. It says that it was known to him, but it's uninformative. We don't know how he has this information. Those facts aren't provided to us as to how the CI has this information, whether it is rumor, chatter. He says that it is that Wiggy is known to him. Known to him how? We don't know. We can't evaluate that information. And he certainly never says, the CI never says that he purchased drugs from Wiggy in the past. That is made up out of out of whole cloth.
Well, except that he does purchase from Wiggy on a couple occasions under police surveillance, right?
He does purchase, he does, it appears. One thing I would like to correct, Your Honor, Justice Green, Chief Justice Green, you mentioned the second buy, and the second buy was the one where the police set up at the residence and observed the red Mercedes leaving the driveway. They do not say who they observed getting into the red Mercedes. Now, maybe I'm
but 5 minutes later, the red Mercedes arrives at the location of the meet, and Wiggy gets out of it. I think that at least is a pretty fair inference, right?
I think it's a fair inference that Wiggy showed up at the meet location
In the red Mercedes.
in the red Mercedes.
And they also saw him leave 10 Abbott and get into the red Mercedes, right?
No, they didn't see him. They saw the red Mercedes leave. They saw the red Mercedes leave. We don't know who was driving the red Mercedes, where it went, who was met.
I think, again, with the short duration of time, I think it's a fair inference that it went directly there without detours.
He's driving a Mercedes. One can travel rather quickly in a Mercedes, and we also don't. He indicates that he headed off in the direction of, direction can be any one of 360 degrees. But that, again, there's no continuous surveillance for that one singular buy. 5 minutes away does not mean that the drugs weren't stored in the red Mercedes. Doesn't mean we can't exclude that he didn't stop somewhere en route. And we also don't know where Wiggy actually lives. The police never conducted any investigation into Wiggy's residence. They relied upon information, as this court has already noted, that there was a domestic incident report some years earlier in which Ms. Goforth identified him then as her husband. Whether they were still married, what the nature of their relationship is, we don't know. We're simply guessing at that. And I would suggest to you, Your Honor, that this is a case where the Commonwealth is taking a patchwork of observations. For the third buy, for example, they're relying upon the fact that they saw a blue Toyota in the morning. At some point that day, there was a drug delivery scheduled, and the blue Toyota appeared for that sale. We don't know what time of day, as the court's already noted. We don't know where that vehicle was in the interim. Later that evening, that blue Toyota was viewed at the 10 Abbott Place residence. We don't know how much time passed, except to know that it was sometime later that evening. This is not sufficient to establish the nexus between the drug selling activity that occurs away from the residence and to establish probable cause to believe that the drugs were stored in the residence. And unless there are any further questions for me.
So I know you rely on Tina and some other cases, but are there any cases post-Escalera that you want to direct our attention to?
Your Honor, I think that probably the strongest case for the Commonwealth, which doesn't advance their cause, is Commonwealth versus Clagan. And in that.
But do you have any that find no probable cause that are post-Escalera that
Your Honor, I don't believe that there is any case that finds probable cause where you are lacking continuous surveillance of the vehicle from the home to the buy and then back to the home.
My question is very specific. Do you have a citation? Is there any case post-Escalera you want us to look at that finds no probable cause under similar circumstances? Is there a citation or is there not?
No, because I don't believe that there are any similar circumstances to this one. This case, Clagan was a close case. This case does not meet the Clagan threshold.
Clagan is pretty similar, I would say, to this case in that it seems like in Clagan, they also didn't have too much information that the target premises was the suspect's residence. They saw the suspect's father going in, and that was pretty much it.
They saw the suspect's father.
Why do you say that Clagan is different?
Well, in Clagan, again, what you had was continuous surveillance. So the police have followed an individual from the residence, and as Chief Justice Green wrote in Pena, an individual's location before a drug delivery transaction is a lot more significant to the analysis than their route and their location afterwards. So in Clagan, what you have is that continuous surveillance from the residence to the sale. We don't have that. And we cannot make the assumption, even if it is a shorter period of time, because we don't know where the buy was, where that buy was located. It took 5 minutes, allegedly, for them to travel to the buy location. Well, the buy location could have been 3 blocks away. It doesn't take 5 minutes to get 3 blocks. We just don't know. We have to make up facts that haven't been presented by the Commonwealth, and we need not do that.
Are the amounts sold in the affidavit?
The amounts sold are not in the affidavit.
What I thought.
No, we don't know.
We can't
Where do we know
rely on the variable amount factor.
No, we cannot rely on the variable amount factor. We also don't know the amounts that were paid. So we cannot make the inference that Wiggy had easy, ready supply to a large quantity of drugs, suggesting that they were there. And if there's
anything else?
There's nothing else from me. Anything else from the panel? And if not, I'm happy to answer your questions. Otherwise, I'll simply rest on my brief.
I think that concludes it. The case is submitted. Thank you both for your argument. We will